Okay, hi everyone. It's really a pleasure to start this year seminar series, Axis of Protection. Good afternoon. I am Anna Biduska. I am a professor of law at the University of Exeter Law School, and it is my pleasure to welcome you to this online seminar. This is a seminar that is part of the Axis of Protection seminar series that is co-convened by Dr. Lawrence Hill-Cothran from the University of Bristol, Dr. Ruvi Ziegler from the University of Reading, myself, Dr. Annika Jones, and Dr. Kubu Machak from the University of Exeter. It is a seminar series that has run since 2013 and is currently funded by the Society of Legal Scholars, a small research grant. We usually hold 3 to 4 seminar series annually, and the goal is to invite a diverse range of external speakers to present their new and original research across a variety of topics relating broadly to international legal protection of human rights. Today's seminar is also organized with the support of 2 research centers at the University of Exeter, the Exeter Centre for International Law and the Science, Culture and the Law Research Center at the Law School. Before I start to introduce our brilliant speaker of today, I would just like to say that we will have 2 more, actually 3 more seminars. And the next one starting.
Meeting.
I think someone is not on mute.
I'm muted.
Okay, thank you. And yeah, so the next seminar will be in Bristol on the 1st of December, and the next one in Reading on the 8th of February. Perhaps Lawrence or Ruth, you can put the links for the Eventbrite on the chat for our audience if you would like to. And with that, I would like now to turn into our speaker. It's a fantastic opportunity that we have today to hear from Professor Eleni Kosta. She is a professor of technology law and human rights at the Tilburg Institute for Law, Technology and Society at the Tilburg University in the Netherlands. Eleni is conducting research on human rights with a focus on privacy and data protection, specializing in electronic communications and new technologies. She has been involved in numerous EU research projects. For example, in 2014, she was awarded a personal research grant for research on privacy and surveillance by the Dutch Research Organization. And she's member of a number of different international organizations and for example, observer to the Europol Financial Intelligence Public-Private Partnership. So a great honor to have you here today, Eleni, and I know that it is a busy time, so thank you so much for making the time to talk to us today about this super interesting topic on data protection concerns and how they interact with cybersecurity. So we will listen to your talk. I understand that you'll be happy for people to ask questions as we go. Alternatively, we will probably have some time for Q&A anyway at the end. Questions for the audience, you can put your questions on the chat or you can raise your hand if you'd like to come in and ask your questions directly. So it's a real pleasure to have you here, Eleni, and without further ado, the floor is yours. Thank you.
Well, thank you very much, Anna. That was a very warm introduction. It's really my pleasure to be here, even virtually. I don't have much to add because you actually said everything. I would really like to welcome people to ask questions. If you don't mind turning on your cameras, that would make my life even more interesting at the moment. It's nice to see the interaction in the faces of people. What I have planned for today is a presentation on data protection concerns and cybersecurity. And of course, this is a topic that you can approach from very diverse angles. What I have designed today is not to go into very detailed explanation of what is cybersecurity, how many laws we have, what is data protection, how many laws we have, blah, blah, blah. I will give you an overview, and I will try to show you where are points that elements and issues and provisions in various legal documents that raise concerns, as the term that I used in the title of my presentation. And Anna very nicely picked out of my CV that I'm an observer in one of the groups of Europol, and I'm actually very critical of Europol in this presentation. So I find it interesting to share this these issues with you. So I have structured my presentation. Let me see how I can change my slide. I have structured my presentation as follows. I will give you a very brief introduction to who we are, so who I am and who we are here at TILT. I will provide you with a brief overview of the relevant legal documents relating to cybersecurity and data protection. I then will delve into key provisions of the GDPR that are important to keep in mind when we discuss cybersecurity. I will specifically focus in the fourth section on automated decision making, including profiling, which is regulated in Article 22 of the GDPR. And I will end with some concerns for the future and see whether we are actually looking for the big bad wolf when we regulate cybersecurity in Europe. So TILT is the Tilburg Institute for Law, Technology and Society. I realized that this picture on our website is probably the most appealing, not the most appealing, but this is what we try to do. We try to work with other people, with technical people in developing technologies. We are an interdisciplinary center. We have about 70 people structured in 3 teams. And I am actually the research team leader for a team on privacy and data protection and cybersecurity, cybercrime. And we recently came up with a fancier title called Fundamental Rights and Technology, because that was just too much what we had here. We have 12 members of staff, most of them tenured, and 9 PhD students in our team, and we are growing. We are involved in a number of projects, both European and national. And the project that I think is most interesting for what we discussed today is called Intersect. It's a very large 7-year project funded by the Dutch research organization, the NVO. And it is about creating a secure Internet of Things. So we have consortia from several universities in the Netherlands working together on cybersecurity issues with different backgrounds and coming from different disciplines, supported by a very large number of private companies that are based here in the Netherlands. So this is actually what we consider to be one of the initiatives on cybersecurity via public-private partnerships. Because we cannot find the best way to solve cybersecurity problems just by doing theoretical research or by collaborating between academics. We also work on research studies. So we recently did a study for the Dutch National Cybersecurity Center on the impact of the NIS2 directive. The NIS2 directive is the Networks and Information Security number 2 directive. So there is an old directive that is being revised at the moment. The final text is not out yet, but still the Dutch National Cybersecurity Center wanted to be proactive. So we made an analysis on the texts that were available, and this is public on the internet. If you're interested, I can share it with you. It's the majority of it is in English. So that's a little bit about who we are. So I know this is usually the part that we are not as interested in. So I would like to move to the actual content of the presentation. So the cybersecurity regime in Europe is expanding. Back in 2014, the European Union adopted a directive, so-called Cybercrime Directive, which regulated attacks against information systems. A few years later, in 2016, it adopted the Network and Information Security Directive, which, as I already mentioned, is currently under reform, and we expect the final text of the NIS2 directive by the end of the year. We have the Cybersecurity Act that was adopted in 2019, and at this moment there are just so many initiatives going on. There is a Cyber Resilience Act that has been just proposed, and there is a combination with a number of acts that regulate data, so not cybersecurity as such, but a lot of a lot of concrete legislation on data, not necessarily personal data, which gives a nice opportunity to get new PhD students to work on the interaction between all these different documents. The NIS2 directive, so the Network and Information Security 2 directive, is part of the new security strategy that was presented by the European Commission that aims at the protection of critical infrastructure as a strategic priority. And this is something that is very relevant nowadays, especially after the impact of the war on the access to energy. We are all wondering and worrying whether there will be enough energy supply for everyone in Europe, etc., etc. And NIS2 is expanding the number of infrastructures that are considered critical, including, for example, space, something that was not there in NIS1. The European Parliament adopted its report in November last year. The Council adopted its general approach in December 2021, and the trilogue discussions are still ongoing. That is the core for the cybersecurity documents that we have at this moment in Europe. And something that I would like to clarify is that most of them are not really focusing on personal data. So cybersecurity acts, all of these acts are mainly focusing on how do we protect infrastructures, how do we protect data, how do we ensure companies are regulated when they act, when they share data, but not necessarily personal data. And this is where the difficulty arises on how to balance this type of frameworks with data protection when actually personal data are involved. So, for example, in the field of energy, mainly the energy infrastructure is regulated under the NIS directive because it's considered a critical infrastructure. There is a new energy directive that was adopted in 2019, if I'm not mistaken, that has some provisions about the GDPR, so the General Data Protection Regulation, because we observe this tendency to have a mix of infrastructure issues, and also the involvement of citizens. So citizens that are using solar panels that are providing energy back to the infrastructure, to the central energy supply system. They do that in a way that their personal information is processed. So the identification data of the individuals, how much consumption do they have, how much production do they have. The production is not so much of a problem, but the consumption that is read through the smart meters can actually reveal a lot of information about the individuals. And in this instance, we see already a tension between the cybersecurity, the NIS provisions, and the provisions on the protection of personal data. So the protection of personal data is not a European novelty, as we tend to believe. We always talk about how, I don't know how familiar you are with it, but the Europeans are very proud of their data protection laws. But actually, at this moment, more than 100 countries across the world, around the world, have comprehensive data protection laws. There are over 40 countries that have pending bills, and many countries have sectoral data protection laws. So even if they don't have a national piece of legislation that applies across sectors, they have sectoral ones, either regulating processing of personal data in telecoms or in health or financial services. These are the three sectors where we usually see sectoral legislation on data protection. Some law firms, for example, this is from DLA Piper, they have interactive maps that where you can see whether countries have data protection legislation in place and whether that is considered robust in relation to the European standards. So as you can see here, we can see that Europe, China, Australia, and the US are considered to have quite heavy regulation and enforcement of data protection, while several African countries don't even have that, and there is quite some work to be done there. I already referred to the GDPR, so the General Data Protection Regulation, which was adopted in 2016, and it regulates the processing of personal data and the free movement of such data within the European Union as a follow-up of the old Data Protection Directive. But this is not the only piece of legislation we have in Europe that regulates processing of personal data. Actually, the landscape is quite complex, and we tend to forget the rest of it. Together with the GDPR, the so-called Law Enforcement Directive, the LED, was negotiated. But the problem was that it was in the shadow of the GDPR, so very few scholars and politicians really focused on it. The LED regulates the processing of personal data by law enforcement authorities for concrete purposes relating to the prevention, investigation, detection, or prosecution of criminal offenses. So it has a very concrete scope of application. But I have to say that if we think about the tendency of privatization of policing, we come across a lot of issues with regard to the applicable framework, whether it would be the GDPR or whether it would be the LED, and a lot of public-private partnership initiatives in order to combat crime. Such initiatives are very common in the field of online criminality. We see issues where the scope of application of these two legal instruments is not very clear. So we have issues of application of the right one. Next to them, there is the so-called EU Data Protection Regulation, which regulates the processing of personal data from European Union bodies. And next to those, there is the so-called e-privacy directive, which was part not of the data protection framework, but of the electronic communications framework. That is a directive that's quite old. It was adopted in 2002. And there has been a proposal for its amendment since 2017, but no consensus has been met yet. So it's more than 5.5 years down the road. There's a lot of conflict and tension between regulators and private companies on a lot of provisions relating to processing of cookies, processing of traffic data, confidentiality rules. So I'm really wondering when we will get this new law, because an old directive of 2002, although it has been amended a couple of times, it's not really meeting the needs of today's communication systems. So in this patchwork of rules and laws that I just presented you, there are a number more. The so-called Europol regulation that was revised in spring this year. We have the European Public Prosecutor's Office regulation, the so-called Eurojust regulation, next to the, I mentioned here the EU Data Protection Regulation because there's some overlap in the scope of application. So I hope I convinced you that the framework is already very complicated. So we need to take into account a lot of rules when we have issues of cybersecurity and privacy, when we have personal data that are being processed in contexts of online environments. On top of that, there was a regulation of 2018 that regulated the flow of non-personal data. So as I already told you in the beginning, it's not only about personal data, there is also a big body of literature and some legislative instruments on non-personal data. So what are we going to do? Sorry, there is also a proposal for the so-called Data Governance Act, which sets out conditions for the reuse within the European Union of certain categories of data that are held by public sector bodies. So trying to regulate public sector information, establishing a notification and supervisory framework for the provision of data sharing services, and establishing a framework for a voluntary registration of entities that actually collect and process data that are made available for altruistic purposes. So we have a lot of charity work being done. So the Data Governance Act is there to do what the title says, to help with creating a governance system for data. And next to it, there is a so-called Data Act, which aims to create a fair data economy. So we are working a lot with colleagues from competition law, because all these instruments, they are actually in the intersection between fundamental rights when individuals are concerned, human rights, but also a lot of company interests, a lot of business interests are involved. So I hope I managed to give an overview of several of all this matrix of legal instruments we have as a starting point for the discussion. But in order to avoid really exploding your brains with all the details, I will focus mainly on the rules of the GDPR, but I'm happy to answer any questions to the extent that I can, of course, because I cannot claim I have managed to follow all these debates in detail. So I would like to ask you at this point if there are any questions about this overview of legislation on cybersecurity and data protection. No, you will have also the slides. You will get the slides afterwards, I guess, Anna? Is there a question?
Yes.
Yeah, can I ask a question from you? Good
Yes.
afternoon. My name is Khoyam Osman. I'm a PhD student here. So my question is that you mentioned there's around 100 countries, they have made their legislation regarding the data protection. And around 40 countries are in process, and there is a sectorial legislation is coming up further. So if every country will create a data protection regime, so how this will complicate the legal regime for the corporate sector? They are moving in one country, another country, another country, and they have a businesses around the world. So how this will complicate, this structure will complicate their activities, and that will create a more restrictive regime for them to operate. How this will affect overall cost to commercial sector?
Well, this is actually an excellent point. This is one of the major problems that we are facing in the field of data protection at the moment. So naturally, data protection and processing of personal data is not a national issue. The majority, or not the majority, but for companies, as you very rightly said, the problem is when they want to be active in several countries, or when they need to get data about citizens that are based in another country. So when the whole discussion about data protection started in Europe back in the 70s, the OECD picked it up as a problem very, very early. So already in 1980, so that's more than 40 years ago, the OECD prepared guidelines on the exchange of data between countries. So they called it trans-border data flows. And these guidelines were updated back in 2013. These guidelines are considered the basis to facilitate the exchange of data and the transfer of data between countries. And these are considered as the guiding document for national legislators to prepare their laws. Is this happening? Obviously, these are guidelines, as the name says, so these are not strict and binding rules, which is why we have a lot of conflicting rules, or rules that are much stricter in one country compared to the legal framework in another country. The position that the European Union took when the whole data protection framework was revised, and the revision resulted in what we have today as the GDPR, was that they decided to take a very strong approach and regulate not only providers that are established within the European Union, but regulate the processing of personal data by providers that are established outside the European Union, to the extent that they are offering goods or services to European Union inhabitants, so not necessarily citizens, and at the same time to providers that are monitoring the behavior of people that are established in the European Union. So they created what we call the long arm of the Brussels effect, the long arm of the GDPR. How easy is it for companies to comply with that? That's another question. So the GDPR tried to solve the problem within the European Union. At that time, we had 28 member states. The UK was still a member state of the European Union. And the GDPR aimed at harmonizing, at least at European Union level, the rules. So at least companies could come to the European Union and be confronted with one legal framework that they needed to comply with. To a large extent, the European Union succeeded in that, not completely, if you ask me, because there are quite a few exceptions. But the problem is not solved at the international level. So the Council of Europe is taking a lot of initiatives, trying to create a framework, because there is a convention under the Council of Europe, Convention 108 from 1981. But this is not ratified by so many member states, etc., etc. And there are a lot of initiatives by the Council of Europe, supported by the OECD, and also United Nations, United Nations, that they try to create a convention that would be at a supranational level and would be adopted by a lot of countries across the world. This has not happened yet. And this has not happened yet, and I don't know whether they will manage this in the coming years, because there are a lot of political tensions. So there are countries, like several countries in the European Union, I would dare say the European Union itself, that says we have a very high level of requirements and protections that we don't want to go down from. You have other countries that say, yes, but we want more exceptions when it comes to the public sector, or so for example, Canada, they have two different systems. They have a data protection framework for private sector, data protection framework for public sector. So these tensions do not allow to find a common framework at international level. So what is happening now is a lot of burden for compliance of international companies when they are active in several countries.
Oh, thank you very much. I will just elaborate, if you will help me for that. If you will see the Brexit, that now the companies are mostly operating in the European Union, and they are reluctant to come back to the UK to work here because they think this structure is more complicated for us. So now the businesses want a smooth business activities. They don't want much hassle. So if this regime is going to be more and more complicated, how this will affect the commercial activities? And because some businesses will want a flexible regime where they could operate very easily rather than somewhere go and there is a big restrictions there.
I'm not sure I follow fully. Do you mean the fact that we have so many laws that it creates a very... Okay, yes, well, this is something that is very highly debated at the moment, whether having so many different laws actually contributes to this environment, secure environment that the European Commission wants to create for companies to work in, which at the same time protects human rights. So that's where the topic of the series of seminars links. So they are trying to find a balance between the rights of the individuals and the financial and economic aspirations of companies. That's what they try to do with the framework. Whether they succeed or not, that's something that we need to see. What I, as a researcher, see is that it is very complicated. It is impossible for me to have a full overview, even if this is my job. So I can imagine that big companies will not have a problem because they will have a large group of lawyers that will be working and making sure that they are compliant. But for smaller companies, that will this complexity will definitely raise issues. And this is something that is discussed in Brussels.
Thank you.
Any other questions? Then I will move to the actual discussion on the General Data Protection Regulation. And because I was not aware of how familiar you are with the details of the framework, I have included a small section on the key provisions so that we have a common understanding on the terminology and the principles that I will be discussing. One of the core notions, of course, in data protection is personal data. What is personal data? And there is sometimes confusion about what is personal data. The GDPR defines personal data as any information relating to an identified or identifiable natural person, which is called a data subject. There are two elements that we need to look into here. It needs to be a natural person, so companies are excluded. We cannot talk about personal data relating to a company. We can talk about personal data relating to members of an executive board of a company, but not of the company itself. So that's a very important limitation of the scope of application of the GDPR. And then that person needs to be identified or identifiable. So it means that we need to be able to single out, not necessarily find the name, the very first name and the last name of that person, but we need to be able to single out and combined with other pieces of information, be able to identify that person. This leads us to the conclusion that truly anonymous data are not personal data. And there we get into discussion with technical experts to what extent can you truly anonymize data, especially when a lot of information comes back from the context. And pseudonymous data remain personal data. And why do I highlight it? Because when we will see a bit later that there are some rules about security of the data, often we get the response from companies that, yes, but we pseudonymize our data, which means that we are left outside the scope of the GDPR. But this is not the case. Pseudonymous data means that these data can be re-identified. So the individual behind the data can be re-identified. And the UK Information Commissioner has prepared a guidance. So I thought that for this audience, the UK ICO is relevant. So I tried to use some examples from your own regulatory authority on what can be indirect identifiability. So a business uses Wi-Fi analytics data to count the number of visitors per hour across different retail outlets. It is not necessary to know whether an individual has visited an individual store or multiple stores before. This involves the business processing the media access control addresses of mobile devices that broadcast probe requests to its public Wi-Fi hotspots. MAC addresses are intended to be unique to the device, although they can be modified or spoofed using software. If an individual can be identified from that MAC address or other information in the possession of the network operator, the business in this example, then the data is personal data. Additionally, even if the business does not know the name of the individual, using a MAC address or other unique identifier to track a device with the purpose of singling out that individual or treating them differently means the data is also personal data. So through this example, the UK ICO tries to clarify exactly what I told you, that you don't necessarily need to find the name of the person immediately. If you can single out through the device the holder of the device, that is enough to render the information personal data. Is this example clear? So in contrast to that, we have the definition of pseudonymous data, which means that pseudonymization is the processing of personal data in a way that the personal data cannot be attributed to a specific data subject anymore without the use of additional information. But because this additional information is available and it can either be held by the data controller or by any other party, these data are considered pseudonymous and remain personal data. Another example to understand the concept of pseudonymization by the UK Information Commissioner is the following. A business uses Wi-Fi analytics data to count the number of visitors per hour across different retail outlets. It is not necessary to know whether an individual has visited an individual store or multiple stores before. This involves the business processing the media access control, so the MAC address of mobile devices that broadcast broad requests to its public Wi-Fi hotspots. MAC addresses are intended to be unique to the device. If an individual can be identified from that MAC address, then the data is personal data. Did I do the same? I'm sorry, I copy-pasted the same example twice. The example here was that there is a list of, we need to see whether the MAC address is combined with other information, and then the company, the business, wants to remove the MAC address and replace it with another identifier. So you have MAC address ABCD, and then they replace it with a pseudonym that is Eleni. The second one is Anna. The third one is Kubo. This does not change the nature of data that remain personal data, because the company has a database that can link back the MAC address with the given pseudonym. So even if to a third party the information is not clear that it relates to a concrete device and consequently to the person behind the device, this is possible quite easily actually for the business itself, because of the database they have created where they have the link between the MAC address and the pseudonym they have used. I already referred to the term processing, data processing of the data. And this is a very general term. Processing means any operation or any activity that is performed on personal data. This can be literally anything: collection, recording, organization, structuring, storage, adaptation or alteration, retrieval, consultation, use, anything, the destruction of the data, the erasure of the data, the actual process of anonymizing data, that is also considered personal data processing. So I have highlighted here that processing includes transfers, including remote access, just accessing, just storing, and the process of deletion or anonymization. The reason why I have highlighted the access or the storage is because companies, especially in the advent of big data and AI, when they see a big benefit in collecting as much data as possible, they have tried to argue that they should be allowed to collect as much information as they can without the data protection rules to apply on them, and only trigger the application of the data protection framework when they actually use the data. So they try to argue that the actual storage, the mere storage, should be allowed, maybe with some security requirements in place, but not with all the rules and all the obligations that derive from the data protection framework. This is something that the European regulator, mainly through the European Data Protection Board, which is, I could call it an advisory board that takes guidance, prepares guidances and recommendations on the application of the European rules on data protection. They have not accepted that. They said even storage, the moment that a company gets access of data, the full data protection framework applies. And here a side note from my side, this is interesting because we see some exceptions in Scandinavia. And I'm not sure to what extent this will still be considered as compatible with EU law. How can we process data now? In order to be allowed to process personal data, we need to rely on one of the 6 grounds that are specifically mentioned in the GDPR. You cannot come up with other grounds. If you want to process personal data, you need to check the GDPR and see whether you can comply with one of the 6 grounds. These grounds for lawful processing are either the consent, and I will discuss them very briefly in the coming slides when the opportunity arises, is consent. Consent is the freely given, specific, informed, and unambiguous wish of the data subject to allow the processing of the personal data. Is the necessity of the processing for the performance of a contract. Is to comply with the legal obligation of a controller, and we will talk about the controller and processor in a minute. Processing is necessary for the vital interest of a data subject. So, for example, if you have an accident and somebody needs to call the emergency services, and they use your phone, no? So there is a processing of your telephone number. That is processing of personal data. That is for vital interest, and that is fine. Or if people at that moment they open your wallet in order to find information about you, to contact your relatives, that is also allowed under the vital interests. Then processing can be allowed as when data are necessary for the performance of a task in the public interest. We see this used a lot for in the context of anti-money laundering. There is a big debate now to what extent public interest can be used or whether it should be used as an exception. And finally, something that's very important for companies in the context of cybersecurity is legitimate interest. Legitimate interest means that the data controller can process personal data for their own purposes, if they can justify that they have a legitimate interest to do that. And it needs, in order to justify that, they need to do a balancing exercise that there are no overriding rights or interests of the data subject. So this is the easy way out for companies, because they can say, you know, I want to process this data in order to send targeted advertising, and targeted advertising is a legitimate interest. So you start a lot of debates. Is this actually legitimate interest? Can we allow it? It's the most blurry term, and this is where companies want to rely on. I also used the term controller. There is another term, processor, next to it, that are very important in the context of data protection, because depending on whether an actor is identified as controller or processor, there are a number of obligations that are deriving from the existing legal framework. So a controller is an entity that determines the purposes and means of the processing of personal data. So for example, the company processes personal data on its own behalf for its own business purposes and therefore controls the data. A processor is the one that processes personal data on behalf of the controller, and this is usually the case when a company outsources the actual processing of the data. So you have a big bank that is processing information about their customers. The big bank is the controller, but because outsourcing it to a company in India is cheaper, the Indian company is the processor. They cannot take any decisions on the data. They can only do the actual processing following the instructions of the data controller. So this is the important definitions of data controller and data processor. We design systems. That process personal data, and we know from the outset that there will be data involved. And the GDPR established the principles of data protection by design and by default as part of the obligations of the data controllers. When data controllers are designing a system, or are preparing to deploy a system that entails the processing of personal data, they need to take that into account from the outset. They cannot just design or deploy their system and afterwards say, well, let's see what we do about data protection now. They need from the outset to think of the rules and to embed them in the design of the system, and to the extent possible to include them, to include the protection of personal data by default. How easy is this? As you can see in the slide, you have different steps in order to do that. It is challenging because, of course, the companies want to make as much money as possible and they want to collect as much data as possible. And the idea of data protection by design and by default is a more rights-based reasoning, where the protection of the data subject should have a primary role in the design of a system. So in order to comply with the data protection by design and by default principle, in the realm of cybersecurity, when companies are designing systems, when companies are designing products, they need to take data protection rules into account at the design phase and implement them implement these rules by default whenever possible. There was a long discussion, for example, on browser settings. Shall we set the browser settings in such a way that are best for companies to collect as much information from the users as possible, or should the default be no cookies, no transfer of data, no tracking, no third-party cookies, no advertising, and then the user should allow it? There has been a debate, and if we interpret the GDPR strictly, the latter would be the preferred approach. The GDPR also, I already referred to it, has a number of rules on ensuring the security of the data. So when the data controller is setting up a system, they need to make sure that they take technical and organizational measures that help in the mitigation of potential risks by, for example, taking measures for pseudonymization or encryption of the data. They have measures that ensure the confidentiality, integrity, availability, resilience, etc. of the data. So we need to make sure, the data controllers need to make sure that they take measures that do not allow for hacking or for leakages or for any kind of manipulation of the data. And this is where there's a lot of interplay with the provisions in the cybersecurity framework, where there are a lot of obligations for providers, especially of critical infrastructure, on security. When critical infrastructures entail also processing of personal data, they need to be read in conjunction with the rules of the GDPR on data security. You can see, I guess, in the news quite often leakages of data, hacking of databases. There was a period when I think almost every day we would see news about databases of with information of credit card information that was leaked, USB memory sticks that were lost or forgotten on the train, and then all the information was exposed. So talking about the security, especially in a ubiquitous environment where you have a lot of devices where personal data are being stored, this is something very important to address. So we can have either these examples that have to do with small devices, but also we have news about very large cyber attacks like this one against the UK's Defence Academy, which, according to the newspapers, it caused a significant damage. So cybersecurity is something that has not been safeguarded, I would say, despite the so many rules that we have established. We are not at a position where we can say that cybersecurity has been achieved. Any questions so that I don't go on without checking with you? No?
I don't know. I think we can continue if you want, but
yeah,
not willing to interrupt.
Okay. There are specific rules about data breaches, because this relates to the loss of data. And the GDPR added the term of personal data breaches, which means the breach of security that leads to the accidental or unlawful destruction, loss, alteration, unauthorized disclosure, or of access to personal data that are transmitted, stored, or otherwise processed. So when a cybersecurity attack takes place, you may have breaches, security breaches, and at the same time, some of these breaches can entail personal data breaches. And the GDPR has concrete rules on the personal data breaches and obligations to notify both the end user, both the customers, as well as the Data Protection Authority. The GDPR says that the Data Protection Authority should be notified very quickly, in most cases within 72 hours. The data subjects need to be informed, so the customers need to be informed without undue delay, and this is a little bit more flexible. In the Netherlands, we had a fine from the Data Protection Authority that was almost $500,000 on Booking.com because there was a data breach, and Booking.com did not report it very quickly. So it's not that they did not report it, it's just that they did not report it very quickly, and here I have the data. According to the Dutch Data Protection Authority, Booking.com, according to their investigation, knew of the data breach on the 13th of January 2019, and they only reported it to the Data Protection Authority almost a month later on the 7th of February. So there, the Data Protection Authority said that this is clearly not in line with the legislation in place. They should have informed us, and the victims of the breach, so the victims were, and that is interesting because the victims were informed 3 days before the Data Protection Authority. So the Data Protection Authority did not like that because they didn't know what Booking.com did in this period with the data that had been linked, what measures they took without consulting with the Data Protection Authority, etc. So they insisted on the fact that within 72 hours, the Data Protection Authority needs to be informed, and then together with the private company, they can see what are the measures they need to take, and the notification of the data subjects can take a bit longer. So for the Data Protection Authority, that was not a big problem. So the fine was quite high, I would say. Next to this, there are rules on the so-called data protection impact assessments. So this is an interesting topic. The data protection impact assessment is a set of rules that changed a lot between the initial proposal of the European Commission and the final text of the GDPR. Data protection impact assessments are foreseen for cases when the processing of personal data uses new technologies, and when there is an additional risk for the individuals. There are three main categories that are mentioned in the GDPR itself as examples of situations where a data protection impact assessment needs to be carried out. And these entail the systematic and extensive evaluation of personal aspects of natural persons, which is based on automated processing. So there we have algorithms used, etc., that result sometimes to profiling. Secondly, when the processing is done on a large scale and it entails processing of special categories of data. Special categories of data are also known as sensitive data, and this is a closed number of data that relate to racial or ethnic origin, political or philosophical beliefs, health, etc. And they are considered as very sensitive which is why their processing is in principle prohibited. Of course, there are a number of exceptions that allows them, but they are so sensitive that we should not process them. And the third category relates to the systematic monitoring of a publicly accessible area on a large scale. And of course, discussing what is a large scale is useful. Do we mean large scale in terms of geographical coverage? Do we mean in terms of amounts of data? Do we mean in terms of impact? So there are quite some discussions there, and there have been some guidelines published by the European Data Protection Board explaining that. So I'm happy to discuss further if you want. So as a rule, in order to carry out a data protection impact assessment, first the data controller, supported by the data protection officer of the company, need to check the rules of the GDPR to see whether they actually need a data protection impact assessment. If a data protection impact assessment is necessary, then the next step is actually to describe the processing. What kind of data does the company collect? How are they using it? For what purposes? How long are they storing it? How are they complying with the principles that we already mentioned? What are the grounds of lawful processing? How do they address the concerns of the data subject? And how do they ensure that they have procedures in place in order to respond to the requests of the data subjects for the protection of their rights, etc. There is a step that most companies try to skip, is potential consultation with your customers. So this is what we are doing. What do you think? How we should do this? What should we change? So this is something that is quite questionable, because it is a nice idea, but it is quite time consuming and costly for companies. After the data controller has described the processing, they need to assess the necessity and proportionality of the processing. Do we actually need to collect so many data? Do we actually need to keep them for so long, etc., etc.? So you have a human rights approach here embedded. And based on that, so from the human rights, you move to the risk assessment. So that's what I find very interesting in the DPIA, that they try to use it both as a risk assessment tool and also as a human rights protection tool. So that makes the life of companies very difficult to manage to do everything in one document. They carry out a risk assessment, and how do they do that? They identify the risks that come out from the processing of personal data for the individual, and they classify the risk as low, medium, or high. It's usually what the UK Information Commissioner's Office suggests. And then the company proposes measures to mitigate these risks. After that, the data protection impact assessment is more or less ready, and the company needs to make sure that they review the process at regular intervals, and how often that is, it depends on the nature of the data, on the type of the company, etc. So this is what the ICO has suggested as a matrix to assess the severity of impact, having harm on one axis and the likelihood on the other. And of course, when you have both serious harm and high probability that this will take place, then this is considered as a high risk, and you need, as a company, to have more risk mitigation measures in place. But what is important, and you should not forget, is that companies should, in these cases, also make a proper assessment of the affected human rights, and you have necessity and proportionality analysis embedded in the data protection impact assessment that needs to be there when the data protection authority potentially does audits, for example. So this is for the data protection impact assessments. And as I mentioned during the introduction, I will not focus on all the data subject rights that are in the GDPR, because there's a very long list. There are transparency obligations, or what kind of information needs to be provided to the data subject so that they are aware of the data processing. They have rights to access the data, to rectify their data, to delete their data, etc. But in the context of cybersecurity, there is one right that is very relevant, and that is established in Article 22 of the GDPR, and it is called automated decision making, including profiling. So according to this article, the data subject shall have the right not to be subject to a decision based solely on automated processing, including profiling, which produces legal effects concerning them or similarly significantly affects them. The wording is very complicated. The data subject shall have the right not to be subject. That is not really a right. So if you read it properly, it is actually a prohibition for the data controller. The data controller should be prohibited from processing personal data that lead to a decision that is based exclusively on automated processing and has legal effect for the individuals. There has been quite some debate about this, because in the law enforcement directive, it is actually a prohibition for the data controller. So exactly the same thing in completely different wording, while the final outcome is the same. The reasoning of the European legislator was to actually make sure that the protection of the citizen is in place, and it should be promoted as a right and not as an obligation to the data controller, even if the final end result will be more or less the same. Profiling is defined in the GDPR as any automated analyzing or prediction of personal aspects that concern the individual's performance at work, economic situation, health, personal preferences, interests, reliability, behavior, location, or movements, and automated decision making. So these two terms are interlinked, but they're not identical. Means any automated decision, so there should be no human intervention. The moment there is a human intervention, the moment there is a human that is even checking the final result, then we are away from the scope of application of Article 22. That has a legal or other similarly significant effect, and the example that we usually refer here is the automatic rejection of a loan. Companies had automatic questionnaires where prospective customers or existing customers were answering questions, and then in the end there was a decision made on whether they are entitled to apply for a loan or not. And that was challenged and led to the introduction of Article 22 of the GDPR, because the data subjects claimed that they need to have a human checking whether they are eligible, because there are factors that need to be taken into account that the algorithm cannot check. And the impact, of course, on the data subjects is huge. In Finland, there was a system introduced on credit scoring that was put on the market, where a tribunal threatened to fine a company with a fine of 100,000 euros on the grounds that it used such a credit scoring system in order to decline credit to a customer. I could not find information whether actually the fine was imposed on the company, but I could only find information about this threat, but I found it interesting. Here in the Netherlands, at the level of public administration, the government introduced a system, a credit scoring system, a fraud detection tool, excuse me, that was called SIRI, that would spot whether citizens were obtaining benefits from the state in a fraudulent way. They created an algorithm, they fed information to the algorithm, and it turned out that the algorithm was only giving out results as hits that related to people from lower income groups, ethnic minorities, immigrants, etc. And that had to do with the training data. So the District Court of The Hague found that there was a huge violation of human rights in this case, and the series system was banned. So it doesn't exist anymore here in the Netherlands. At the same time, we see quite a lot of news on private companies using algorithms in order to select right candidates for positions that in the end these algorithms lead to discriminatory results and have unlawful bias in the training data. So the outcome is that several of these systems enter the market, but they don't survive because they are considered to violate human rights. That's interesting, that the rule is on human rights violations. I refer to consent as a ground to justify processing of personal data, and this is something that companies were using a lot in the past, until they realized that there is a problem. If the data subject withdraws their consent, it means that they don't have a legal ground anymore to process the data, and they need to dig into their databases to take away this data and take away any data that relates to this retracted data. So the data need to be checked all the time, and reliance on consent does not allow companies to have legal security. However, there are cases where consent has to be the legal ground for processing of personal data, like in the case when we have exceptions for the prohibition of automated decision-making and profiling, where a data subject can give their explicit consent and agree to the processing of personal data that leads to automated decision-making and potentially profiling. Automated decisions. So here are some slides from the guidelines of the Article 29 Working Party, which was the predecessor of the European Data Protection Board, explaining this complicated Article 22. So what can be these automated decisions? What types of data can these automated decisions be based on? And the Article 29 Working Party clarified that this can be data that either provided by the individual themselves, data that are observed about the individuals, or data that are derived or inferred from other systems. So there is no limitation on the training data, on the input data, in order to get these automated decisions. Article 22 refers to decisions that are based solely on automated processing. So I already said that there should be no human involvement in the decision process. And the example that was provided by the Article 29 Working Party was that the following. An automated process produces what is in effect a recommendation concerning a data subject. If a human being reviews and takes account of other factors in making the final decision, that decision would not be based solely on automated processing. So when you have human intervention, you need to move away from the scope of application of Article 22. There are a number of suitable measures that need to be performed by the data controller in order to justify the use of an algorithm, and that can be the performance of regular quality assurance checks of the algorithm, do auditing, use anonymized or pseudonymized data whenever possible, and allow the individuals to express their point of view or contest the profile. When this is done by large companies, the norm is that there is an ethics review board established to actually check and assess the potential harms and benefits to society and to the customers from the use of the algorithm. There needs to be a maintenance of a mechanism for human intervention when there is a need and a request from the data subjects, and if possible, to obtain certification or adhere to a code of conduct for the use of algorithm if that exists. you realized already from what I have said that human intervention is crucial. When human intervention takes place, it needs to actually be real. So the human needs to do a thorough assessment, not just a checklist and put a signature just in order to avoid the application of Article 22, if that is the case. So this is a summary of Article 22, just for you to take home. And I would like to go to the last part of the presentation. What are problems that we have faced? And this is where I refer to the data set that was, the database that was created and retained by Europol. So Europol had a very large database of data that came from national law enforcement authorities and referred to suspects, to criminals, to witnesses, all sorts of humans that can be involved in criminal investigations. The European Data Protection Supervisor has the possibility, is assigned in the relevant legislation with the auditing of the actions of Europol in relation to data protection. So they started a very large investigation that resulted in the decision that you see on your screen on the retention by Europol of data sets. The outcome of the investigation was that there was no categorization of data subjects in the database of Europol, meaning that they had all the data in the database and they applied the same rules for all types of data. However, the European Data Protection Supervisor said that when somebody is just a suspect and there is the assumption of innocence, you cannot process this data and use this data in your searches in the same way as the data that relate to convicted criminals. Similar to witnesses that actually have nothing to do with criminal with crimes or even with convictions, of course. And there the fine was very big. The EDPS admonished Europol, and they actually compelled Europol to change their database and update their database within a year in a way to respect the principles of data minimization and storage limitation. So one of the clear messages that the European Data Protection Supervisor gave to Europol is that you cannot just feed your database with all information that you get from national databases or from investigations that are ongoing. You need to filter that information and make sure that in your database only information about special categories of data and data subjects go. They found that the principle of data minimization and storage limitation was also not respected because the data were kept more or less indefinitely, while the DPS said that the data need to be retained for a period of 6 months. And then, of course, Europol did not really like that, so we are still in a phase where Europol is very upset and they're trying to resolve the problem. This made it obviously to the news, and the so-called Europol regulation version 2, so the risk cast of the Europol regulation was put in place by the European Union in order to address these problems. And the Europol regulation, the recast of the Europol regulation was adopted in spring this year. If I'm not mistaken, it was in May, beginning of June, that actually extended the mandate of Europol, and they tried to evade the limitations that were put by the European Data Protection Supervisor. So Europol is trying to do their best to be able to keep collecting data as much as they can. I guess everybody knows who Edward Snowden is, that the big whistleblower from the US NSA. Edward Snowden found that what was happening with the leakage of information from, the excessive surveillance that was carried out by the NSA, but also the GCHQ in the United Kingdom and a number of law enforcement and security and intelligence agencies all around the world, leads to the so-called cybersecurity state that is not that does not respect human rights, and we need stricter rules that will not allow companies and governments, because you have the private sector and the public sector, to do excessive surveillance of citizens. And this is where we actually need to be careful and make sure that the legislation that we put in place is not trying to find who's the big bad wolf, but actually put the individuals in the center, make sure that human rights are given the central role that they need to be given, and not be given the priority to the economic interests of companies. Coming back to the question that we had in the beginning of the presentation. So that was it from my side. This is a big database, as you can see. So very scary to see that all data are saved there. So thank you very much for giving me the time to talk about the research that we do.
Well, thank you so much, Eleni. That was really interesting and very thorough. And we already have one raised hand in the audience. So please, Kubo, go ahead.
Thank you. And I was also trying the clapping function because I really wanted to, applaud you, Eleni, for your talk. I think, you really managed to fit into the theme of this series so well, because that's exactly what we are trying to do, to explore the various forms that the law, broadly conceived, offers as ways of protection. And I think you have covered so many different areas. It was really rich, and so thank you very much for this presentation. I would like to offer just a quick comment on the one small aspect that you covered, and then maybe ask you for your thoughts about where the gaps might be in this framework when we are looking forward. So that's just a spoiler alert, that will be the question. And the comment is just to really quickly reflect on the hack against the Red Cross and Red Crescent servers and the data breach of the beneficiaries of the Red Cross and Red Crescent movement that you included in the overview of the data breaches that we have seen. And I think, of course, the reason why I noticed it is that currently I'm working at the ICRC, but it also made me think about how these data protection concerns can lead to something positive in the long run, even a negative experience like this, because of course it's horrendous when you see 500,000 people affected by something like that. But that started to galvanize the international community around this issue, and specifically in the Red Cross and Red Crescent movement. Soon after that, a resolution was adopted by the Council of Delegates of the movement that stated very clearly that cyber operations against humanitarian organizations are unacceptable. So I think that that's an important normative recognition that this is just wrong, things like that happening. But it also encouraged the various types of activities to forestall such outcomes. And so one of them was to look into finding solutions how to prevent issues like that happening. And one of them is the development of a digital emblem. So how we have the Red Cross and Red Crescent, like the protective emblems in the physical space. Now at the ICRC, we are looking into that with the mandate of the movement. And actually, it's very fortuitous that we are talking about it today, because tomorrow we are launching the report on the digital emblem. So, if people are interested, then for sure they can. I'm not stealing, your thunder. They can look it up on the website, all the details. But it's a public launch. And so that brings me to my question. Seeing that the problems that we have identified kind of tell us where we should focus our normative efforts to develop the law in the future. That would be my question for you. Where do you think that this framework is a bit insufficient? And so, again, with the kind of ICRC, IHLE, armed conflict hat on, one of the arguments is that the data protection framework should reach out into situations of armed conflict, and so provide protection, for example, to members of armed forces vis-a-vis their own state, but also sometimes, for example, to prisoners of war that are captured by one state. And then, of course, they are given some protections by IHL, but does that include the processing of their sensitive personal data? You know, there are some of the debates. And so I don't know if you have a view on this. Maybe, you know, you'll take the question somewhere else, looking at where the gaps are. But those are just some of the things that were kind of coming to my mind as I was listening to your very interesting and inspiring talk. Thank you.
Well, thank you, Kubo. Thank you for, first of all, for the information. So I will look it up definitely, but also for the question, because this is an issue that we have not managed to solve as a data protection community. So I have to say that we have made quite a bit of progress in the last years with regard to the processing of personal data for minorities and LGBT. So there is a big movement on how to protect personal data in the context of such communities. We are not touching upon the issue of armed conflict because we really don't know what to do there. So I don't have an answer to that. Because I don't know how we can actually enforce it. That the problem is the enforcement. And the problem is that if you read the GDPR, I think I tried to say it in the beginning of my presentation, is that the GDPR is mainly aimed at protecting the customers, the users from the processing of personal data, the excessive processing of personal data from companies. We assume that the public authorities will function within the realm of the rule of law. There is this assumption implicit in the GDPR. And this is something that we need to look into, I think, and that's something that I expect to see in the coming years, more and more research being done. I have to say that the United Nations Commissioner on the Protection of Personal Data has addressed this issue, has not solved this issue, but at least has raised it as a very important issue, especially in view of the political developments of the last years that started affecting Europe more, which is not fair, but it is a reality that we need to address, that when such issues start to affect us more, then we start trying to find a legal solution. So I don't have a solution, unfortunately, Kubo, to that. I wish I had, because then I would be unique in Europe with that. I would be very famous, but maybe this is an opportunity to start looking into that. There are exceptions, and I don't know if that helps in the fact that we don't have solutions for that, that there are exceptions in Article 23 of the GDPR on when limitations to specific articles of the GDPR, including the principles and the rights, can be imposed, and situations of national security are there, and I assume that those governments can rely on those exceptions. They can argue that there is an exceptional situation under which they can restrict the provisions of the GDPR. If they do it lawfully or not, obviously they don't do it lawfully, it's another discussion, but there is this exception in Article 23 because the right to data protection is not an absolute right. If we take it to the Charter and we take it to the human rights debate, and yeah.
Yeah, so I mean, I see there are no other hands up, so I'll just say thank you for that. I think it's really one of the big questions. I find it fascinating. Recently, I was at a conference in Tallinn called CyCon, and a group of scholars were launching a book around these issues. So it was co-edited by Russell Buchan and Asaf Lubin. So it's just something to flag for people on the call. But I think that book is excellent in raising a lot of questions. And I think one of the key questions that exactly your answer flags to me is, to what extent is this framework satisfactory? Because maybe, you know, the national security exception can be inflated so much that it will really remove this protective framework from application to such situations. But that, at least from my perspective, I'm not speaking on behalf of any institution now, but from my perspective, that would be problematic, because you have people in armed conflicts who are in situations of great vulnerability who would not be subject to this protective framework. But okay, I'll leave it there. I'm sure there will be others. Yeah, I already see some other hands up. So thanks a lot, Eleni.
Thank you.
Thank you, Eleni. Lawrence, you have a question.
Yeah, thanks. Can you hear me okay?
Yes.
Great. Hi, Eleni. Thanks very much. That was a really interesting presentation, and for someone that comes at this without any knowledge whatsoever, it was extremely accessible. So thanks very much. My question is a fairly basic one, but it sort of in a way struck me as a kind of fundamental issue in law design, and so I wondered to what extent the legal framework at the EU level that you set out, to what extent was that the result of a kind of systematic plan and design of the law here, or would you say it's actually been fairly piecemeal? And did that in some way correspond with the degree of fit to this particular problem?
Well, that's an interesting thing. So the GDPR is not the first piece of legislation we get in Europe on the protection of personal data. We already had the Data Protection Directive that was adopted in 1995, so quite early, you can say, if you think of the internet and the advent of new technologies. What is interesting is that the GDPR kept intact a number of the provisions of the Data Protection Directive. So the principles remain the same. The rights of the data subject remain the same and were enhanced by a few new ones, like the right to restriction, the right to be forgotten, rights that would actually be more relevant for the online, to address, I would say, the digital steps that came in between the almost 20 years between the DPD and the GDPR. However, one of the criticisms against the GDPR is that it ends up into a checkbox. So a list with obligations, and then when the data controller actually says, I did this, I did this, I did this, I'm fine, let's process, without actually getting into a proper assessment of human rights, because that's what the GDPR is claiming to do. It's claiming to be protective of human rights, not only privacy and data protection, but in several instances, including, for example, the data protection impact assessment provisions, or the provisions on the use of reliance on legitimate interest. There is a clear reference to human rights. Does the GDPR manage to do this? The GDPR was heavily lobbied. And the reason why the GDPR was heavily lobbied is because it entailed very, very large fines. The fines can be up to 4% of the global revenue of a company. They can be huge. You have already fines of millions of euros that are imposed by the French Data Protection Authority, or the German one at this moment, against Google, against Microsoft, against very big companies. Of course, these companies were lobbying. They wanted to make sure that there are some provisions that allow them to process data and do their business without too much hassle. So we are somewhere in between. So I am very happy with some of the core rules that are still in the GDPR that are intact. They have to do with the principles, they have to do with the legal basis, for example. But of course, there are a number of other rules that are the result of a lot of lobbying. So if you ask me, I have mixed feelings always. So I'm afraid that it's not ideal for somebody who works in the field to say, yeah, well, we did all this work and the framework we got in the end serves the interests of big companies. But that's what it was about. The European Commission prepared the proposal for the GDPR under the pressure of companies, of American companies, saying we cannot do business in Europe because you have 28 member states and I need to comply with 28 different legislations. So do me a favor and give me a framework that is more harmonized.
And in a way, there's nothing unique here, is there, about data protection law? I mean, I guess this is that risk with, as you say, a sort of proceduralization of the law, which turns it into a box ticking exercise over a kind of substantive understanding of the law, is something that we face in all areas of regulation, isn't it? So yeah, I guess it's one of the risks that come with attempting to codify the law in any particular area. Yeah, but thanks. That's a really useful overview of the background of the GDPR.
Thank you.
Well, thank you all. I don't see any hands, and I am afraid that we're already running out of time. We're a little bit beyond the hour and a half that we had for this meeting. So unless if there is any burning questions in the audience, I will, and I don't think there are, because I don't see anyone. So I will just thank you very much, Eleni, for taking the time to talk to us in such a busy day and give us such an important presentation, drawing the dots between these different areas of highly complex areas of law and data protection, relating also framework relating to cybersecurity. So super illustrative and very interesting for all of us. So
thank you again
so
for the invitation. Very, very nice meeting all of you, even virtually. Kubo, sent me the details of that book because I would really like to look into that.
I think he puts it in
It's already in the chat.
Sorry, because I have two
I'm ahead of the game. Yeah.
I will find it. Don't worry.
It's in the chat.
I'll send you the link to the launch.
It's probably in the other screen. I will see it in a minute then.
On the other screen.
Thanks, Eleni.
Thank you very much.
Thank you, Anna,
so much
for organizing as well.
Well, thank you all. Thank you, Eleni, and thank you all. Bye-bye.
Bye, everyone.
Bye.